Good afternoon, Monica Miller here. This is Legal Tuesdays, where I answer your questions about separation of church and state. Today I'm actually going to discuss the Supreme Court ruling that was handed down on Friday, I think at around 11 p.m. This past Friday, involving a challenge to California's restriction on gathering in houses of worship and how the Supreme Court landed on that. I will say from the start that this was a fragmented ruling. The case was South Bay United Pentecostal Church versus Gavin Newsom. It came down 6-3, so we had 6 conservative justices saying that we're going to lift some part of this ban, but they couldn't even agree upon the basis of it. And then you had the 3 dissenters, which were Breyer, Sotomayor, and Kagan, all saying that science should trump religion, that there's no reason these justices should be replacing scientific judgment. And you have the conservative bloc saying that we can't restrict religious freedom, even in a deadly pandemic. Now, I'm not trying to minimize the tension here, and that religious freedom is, of course, very important. But again, we are talking about a lethal pandemic in a state that has reached ICU capacity in many parts of it, and so these tier 1 counties are those counties that are the most vulnerable. The Supreme Court did uphold parts of this, parts of the ban. So you have a whole spread of the justices and where they land, and they did land with Roberts being the middle ground on saying that we're going to keep the 25% capacity restriction, and we're going to uphold the restriction against singing and chanting, because singing and chanting releases tiny particles that go into the air. Justices, I think it was Justices Gorsuch and Thomas would have just lifted the restrictions in full, and they would have said, bring on the singing, bring on the chanting. They said, while the state has a compelling interest, and a compelling interest was required because the court applied what's known as strict scrutiny. When there's a restriction on religious exercise, the court will apply what's known as strict scrutiny, in contrast with a lower standard called rational basis, or maybe something called intermediary review. But the reason those things matter is it depends on what standard of proof the government needs to satisfy in order for its law or practice to be upheld. So when you're doing strict scrutiny, that means that the government needs to show the highest state interest, compelling governmental interest, and of course, preventing death of many citizens through a very deathly and viral pandemic is definitely a compelling governmental interest. But they also need to show that the aims, the rules that have been promulgated, the rules that have been passed, are narrowly tailored to meet that compelling governmental interest. So you can say, well, we have an interest in public safety, but then enact laws that don't even touch on public safety. So it's not enough to just say, here's my compelling interest, and then we're doing nothing to actually further those aims, but here's a bunch of laws that don't make sense. So there's 2 prongs to that test, and the justices, even on the conservative bloc, that ended up upholding parts of California's ban, still struck down the main ban against gathering altogether, all disagreeing on the extent to which the laws were narrowly tailored to accomplish a compelling governmental interest. The ruling itself was on a motion for an injunction to enjoin the enforcement of the statute, so it's not even quite the final ruling yet, and it was actually an unsigned opinion. So you have different justices concurring and dissenting in the outcome, but as far as its implications for church-state separation, it's somewhat limited. It is a barometer on where the justices certainly stand when backed against the wall on public safety versus religious gathering. We know that there's already been a shift in terms of the Supreme Court's view on this from last year till now, with the addition of Barrett and with the tragic death of the late Ruth Bader Ginsburg. We had several rulings last year in which these bans were upheld, 5-4, with Roberts actually leaning on the progressive bloc. And now we have a solid 6-3 ruling against such a ban, with Roberts being the moderate, sort of coming up with a middle ground of saying 25% capacity, no singing, no chanting, yet we still have the allowance of these church gatherings altogether. So, naturally, again, Kagan, Breyer, and Sotomayor dissented, saying that California's response to the COVID pandemic satisfies that neutrality rule, that from the idea of that the government has to be neutral with respect to religion, so it can't obviously create rules that only apply to houses of worship, but then leave out, concerts or something like that. And so Justice Kagan and Breyer and Sotomayor were saying we don't see any issue with this being selectively enforced against churches. And they say the restricted activities include attending a worship service or political meeting, going to a lecture, movie, play, or concert, and frequenting a restaurant, winery, or bar. So the activities are both religious and secular, and many of the secular gatherings, too, are constitutionally protected. What's also significant is that this ruling did encompass Barrett's first signed opinion since joining the court in October. She focused on the singing and chanting component of the ban and said, so she already agreed that she wanted to, she sided with Roberts in terms of 25%, but she said it was up to churches to demonstrate that they were entitled to relief from the singing ban, but that in this case they still had not. But she said it remains unsettled as to whether the ban applies evenly across the board in California or if it favors certain sectors. So it's not, this isn't the worst ruling. This isn't the same as us seeing something like the Espinoza case that we got last year. There's certainly a lot bigger blows to the Establishment Clause, to separation of church and state than we've seen. But this one is a good clue as to where the justices stand on church-state separation, on religion. Not surprising stances, but nevertheless, certainly a sobering wake-up call to what the new Supreme Court is and how we're going to need to plan and defend against attacks on religious freedom, true religious freedom, going forward. And with that, I will talk to you on the next Legal Tuesdays.